If you are arrested, you will stand before a judge within 24 to 48 hours for your arraignment. The clock is ticking, and what you say during this brief hearing will dictate the outcome of your entire case. We are going to walk through a 15-minute playbook. Follow these steps and you will protect your freedom while preventing the government from gathering the exact tools they need to convict you. This diagram shows the core difference between a civil lawsuit and a criminal prosecution. In a civil case, private parties are usually fighting over money damages. In a criminal case, the state is actively trying to enforce punishment and take away your physical liberty. Because the stakes involve jail or prison, the U.S. Constitution provides you with a heavy set of procedural armor. But that armor does not equip itself. You have to actively choose to put it on. Walking into that courtroom thinking you can treat this like a civil dispute, hoping to explain away a misunderstanding and pay a fine, is the fastest way to lose your freedom. Step 1. The judge will formally read the specific criminal statutes you are accused of violating. This scale illustrates the burden of proof. In a civil court, a plaintiff only needs a preponderance of the evidence, about 51% certainty. In your criminal case, the government must prove your guilt beyond a reasonable doubt, which pushes near 100% certainty. Notice how heavily the scale tips toward the prosecution. They have to do all the work to prove their claims. Your primary job is to avoid helping them. The reading of the charges is an information-gathering exercise for your defense. Do not interrupt the judge. Do not argue the facts. Just listen to what the state thinks they can prove. Step 2. When you are given the chance to speak, your very first requirement is to explicitly tell the judge you want an attorney. The Sixth Amendment guarantees your right to legal representation. If you are facing incarceration and cannot afford to pay private fees, the government is required to provide a lawyer for you. This shield represents protections secured by the Supreme Court case Gideon v. Wainwright, ensuring that wealth does not dictate your access to a legal defense. A public defender brings an immediate advantage to the room. They know the specific local prosecutors, they understand the judge's habits, and they navigate these procedural rules daily. By explicitly invoking your Sixth Amendment rights, you instantly shift the burden of legal combat off your own shoulders and onto a trained professional. Step 3. Alongside your right to an attorney, you must invoke the Fifth Amendment. As established in Miranda v. Arizona, this is your absolute right to remain silent regarding the events of your arrest. Without this protection, you walk into the explanation trap. Almost everyone feels an overwhelming urge to tell their story, to clear things up. Resist that urge. The prosecutor is in the room taking notes. Any explanation, apology, or excuse you offer becomes on-the-record evidence that will be used against you later. In a criminal court, silence is not an admission of guilt. It is a tactical, constitutionally protected shield that starves the prosecution of easy evidence. Step 4. The judge will ask how you plead to the charges. You will state, "not guilty." You say this regardless of the actual circumstances of your arrest or whatever evidence the police claim they have. Look at this flowchart. Pleading not guilty is not a factual lie to the court. It is a procedural mechanism that physically blocks the fast track to sentencing and forces the system down a longer path toward discovery and negotiation. Entering this plea is the only way to preserve your defense attorney's ability to investigate the police's claims and negotiate a better outcome. Step 5. Navigating the bail decision. The judge is evaluating your flight risk and setting release conditions. They are not passing judgment on your guilt. The judge has 3 primary options: release on recognizance, cash bail, or detention. To secure the best path, your attorney will present specific mitigating factors like community ties, employment, and a stable address to prove you will return. Preparing these mitigating factors ahead of the 15-minute hearing maximizes your chances of fighting your case from the comfort of your own home. Your 15-minute hearing is over. You didn't confess, you secured legal representation, and you forced the state to prove their case. You now transition to the pretrial phase. This is where the real defense work begins. Through a process called discovery, your defense attorney will demand the police reports, body cam footage, and any other evidence the prosecution intends to use against you. The criminal justice system is highly intimidating by design, but the U.S. Constitution provides absolute protections at every single phase, as long as you actively use them. Keep this checklist in mind. Listen to the charges, invoke the Sixth Amendment, Invoke the Fifth Amendment. Plead not guilty. Prepare for bail. Follow these rules and you are ready for the next phase.